issues. So we're going to go through some of the new risks that we're seeing and how we can draft our contracts better, how we can revise them to provide the most protections going forward. So that's just me. Here's Josh. All right. So the newest thing out is the Avoid Act. In December of last year, Governor Hochul signed the Avoid Act, and that is a fundamental change to third-party practice in the state. So now what's going to happen is that there's strict limitations on when you can implead potentially liable parties. Previously, CPLR section 1007 didn't have a strict deadline on when you had to add potentially liable parties. And what happened was the defense bar was waiting until the last minute to add parties, and they were using that as a delay tactic. So this litigation was put forward and signed to avoid late impleader. So what they believe cases will progress at a quicker pace. So again, before the Avoid Act, people would wait until depositions were finished, discovery was exchanged, and you knew who could be liable, and you could target them via third-party practice. There wasn't an urgency in determining who could be liable. You would let everything kind of play out, let the chips fall, and then understand who else may be liable. This change now sets strict deadlines. This law has 60-day deadline for contract claims. These are your contractual indemnification claims. This is 60 days from your answer. And then for non-contractual claims like contribution, common law indemnification, it's 60 days from discovery for non-contractual claims. So it's a cascading timeline for a successive impleader. So once an answer is asserted, a 60-day calendar starts. So if you're a second, third-party defendant, you put your answer in, your deadline to then bring in who you believe may be liable starts over again. So what this is going to do is going to force everyone to look at everyone on the project site and figure out who may be liable. And it's going to, in my opinion, it's going to add a lot of parties to lawsuits that really shouldn't be parties. And they're being added just in case. And they're going to make motions to dismiss. And then there's going to slow down the process in the beginning. So before any information is exchanged between the parties, there's going to be all these parties brought in and have to defend these contractual indemnification claims. There's going to be motions to dismiss, which in New York, if you file a motion to dismiss, it stays discovery. So now the case is kind of stalled before it's even started. And I don't know how many people here are lawyers and practice in New York State, but it could take months or a year to decide a motion to dismiss. So you're sitting there for a year. You don't get out of the lawsuit. You're incurring costs, and nothing's happening. It's not going to have the effect to move cases along as I believe the plaintiff's bar and the governor envisioned when signing this law. Here's just the framework which we just discussed, the 60 days for first third-party claims. So as you can see, each deadline runs from the service of the immediately preceding third-party answer. This is the change which I glossed over before, is that before you didn't have to rush to the court to assert claims against potentially liable parties. You could wait until you knew that there was some meat to the case, and you would actually be able to get some kind of recovery from these third parties. Now, owners and GCs who, as everyone here knows, are automatic statutory defendants in your Labor Law 240, your Labor Law 241 sub 6 claims, your Labor Law 200 claims, which are the thrust of all personal injury accidents on construction sites. They're going to have 60 days from their deadline to bring in all responsible parties. A lot of times, these owners are signing contracts with a GC, with a contractor, and they don't know who they're subbing the work out to. There's not from the contracts I've worked on, there's not a formal way to determine who may be liable. So that has to change. So the courts can give extensions up to 30 days. There's some other deadlines for grave injuries and unknown employers, but that still will require you to file within 120 days. So this is a very strict deadline, and the court had the law makes it clear if you miss this deadline, you're barred. So if you don't assert these claims, you lose them. Even if at a later date you discover evidence which would point put all the risk onto that party, you're out of luck. So the tips and pointers I'm recommending to my clients and recommending to everyone here when you're drafting your projects, either as an owner, a GC, or a contractor, is you're going to want a complete project directory at kickoff of the project. So you know who is who hired who works with who, how that fits in with your indemnification language. You want to contractually require the contractors and subcontractors to, within 48 hours of a new subcontractor being engaged, to supplement this project directory. This is going to help with the identification stage, which is necessary due to the 60-day deadline to assert these claims. So if what I'm recommending to everyone to avoid the pitfalls of the Avoid Act is to have a project directory and keep it maintained and updated on a regular basis, and do that early analysis as to how these parties fit into your indemnification agreement. So if one company's employee gets hurt, who would owe you indemnification through the agreements? It's gonna force a lot of work to be done early on, but I think that's the way to get around this and not get stuck losing a claim. So the next thing I want to talk about is more of a general issue that I see with construction contract is the scope of work. The scope of work is the most important part of a contract for the contractor, because that tells them what they're going to be doing on the project, what their milestones are, what their standards, what their specs are. And what happens is this leads directly to change order work. If there's a dispute as to the work you performed, whether it's in your scope of work or it's compensable as a change order, this is where having a clear and unambiguous scope of work is going to come into play. So we're going to talk about ways to draft your scope of work to avoid these potential issues. So the 4 root causes of scope of work disputes are ambiguous work descriptions, contradictory or inconsistent plans and specs, misinterpretation of contract requirements, and then finally differing expectations about work to be performed. Both parties can look at an agreement and think in good faith that it requires the other party to do something that it doesn't, and that's a good faith dispute. But you can avoid that by narrowly tailoring, defining all of your scope of work clauses. So what's important here is that courts look at scope of work as a contract, so they're going to interpret it pursuant to the plain and unambiguous language of the contract. If you have a conversation with the party that says, we're not going to charge you for that, that's separate, that's not going to be admissible to the court. They're not going to consider that if they find your contract language to be plain and unambiguous. If the court finds your contract was poorly drafted and it was ambiguous, then you can start bringing in the secondary considerations, whether industry custom, the party's course of dealing, and context surrounding the bidding and all the communications. You don't want to get there because that's expensive. You want to have a ironclad, solid scope of work provision that lays out everything you're going to do and what you're not going to do. So this is just quickly what a scope of work is. It's the blueprint. It defines the scope, expectations, and responsibilities. So a great scope of work leads to a project that goes on without any delays, any disruptions. Everyone gets their work done in a timely fashion. Everyone's happy. Everyone stays on schedule. You meet substantial completion pursuant to the documents, and you could avoid a lot of our issues. So a lot of people in this room probably have seen the AIA contract. That's the standard construction contract that a lot of people enter into. They kind of stop using the standard form AIA contracts, and what you're seeing a lot more is a Frankenstein version where people are taking provisions from the A101, adding in provisions from the A201 just to kind of make their own contract, which is fine, but you have to understand who the AIA is and what their intention is. The AIA is the American Institute of Architects. Their intention is to protect architects. So our owners and architects are going to be in the better position if you're using a template AIA contract. The consensus docs, which is another version of standard template agreements, is created by people in the architect, engineering, construction field. So that may be a little more favorable to your contractors and not to your owners. So it really depends on who you're representing. That'll tell you which form to use and how scope of work is going to be defined. The AIA provides you to be able to work under protest. So let's say you have your scope of work and someone tells you, here's a change order. I want you to do X, Y, and Z. And you say to them, that's not within our scope. You need to pay us more. Obviously, there's going to be a dispute because they're going to fight over whether that work is included in your scope or not included in your scope. AIA 201 will require you to proceed with the work despite disputes. So if you're a contractor, you want to fight this language. You don't want this language in your contract because your biggest negotiation tactic, your biggest bargaining tool is having the ability to say, I'm not doing work until we figure out whether this is scope work or not scope work. So this provision requires you to continue working, maintaining your objections, and then coming at a later time after the project's finished when the owner is happy, and what they don't care about your relationship anymore because they've gotten what they wanted, the owner's happy, and then then that's your issue with working under protest. So when you have scope of work issues, you have to make sure you're maintaining all filing claims, documents, and documenting all work under protest. And then you need to be able to immediately establish why it's not scope work, why it's separate from the scope of work. And then you also there's another consideration is that does your scope of work identify when the statute of limitations is going to run? A lot of times people's scope of work ties their work to substantial completion, where if you're a demo contractor, you're done with your work way before substantial completion. But if your scope of work says your work is completed at substantial completion, the statute of limitations begins to run at substantial completion. So it leaves you open to potential liability for years longer than you intended. And this goes for all other trades. People who are in and out before it's finished, electrical and plumbing subcontractors who go in there, put up all the rough work, then their work gets covered. They're gone. They're off the project, but their statute of limitations has not begun to run yet. So these are my practice points to people when they're drafting scope of work. You want to make sure that there's a list I put on these slides, a list of terms that you want to make sure your scope of work includes. What governs the work? What's your scope of work? What are your deliverables? What are the timelines? What's the cost of your project? And then you want to have an overview of a project. The scope of work needs to define exactly what needs to be accomplished for the project to be considered complete. You want to have exclusions in your scope of work. So you say what's not part of your scope of work. That way, if something that they're asking you to do is clearly excluding your scope of work, you have a very, very good chance of it's found to be additional work and subject to a change order, and you get additional compensation. Also, a lot of these scope of work provisions, as I'm seeing, they use these very vague terms: all related materials, all related items, all work shown in the plans and specs. That's bad because you can draft your scope of work based on a document, one version of the specs and one drawing. And if you don't specifically limit your work to that design and that spec, and there are subsequent design and specs issued, and your language says all work shown in the plans and specifications and is not tied to a specific document, you're going to get caught having to do all the additional work required by the specs and the drawings, which you didn't agree to do. And you're not going to get paid for that. That's going to hurt your bottom line. That's a significant risk that everyone in this room wants to avoid. You want to be able to, when you make your bid, you build in there a profit for you to keep, and you want to make sure that you get that profit. And if you're caught doing additional work that wasn't in your bid, your profit becomes smaller and smaller, and then you're wasting money, you're wasting time. So I like to, you have your detailed list of deliverables and boundaries, what's included, what's excluded. You also want to identify work by trade and then have key deadlines, phase 1 complete by X date. This way you're protected from delay claims. If your scope of work says that your work was going to be, your phase 1 is completed by X date and you meet that, and they try and come after you for a delay damage, that's evidence you can use to show that you didn't cause delay on the project. So then you also want to know what materials. Let's say the owner wants you to provide materials. Your scope of work can't just say to supply all materials per specs, because again, if the specs change after your bid is issued, you're now required to supply all materials. That's going to eat away at your profit. So you want to be able to identify exactly what you're going to supply based on the spec and drawing you rely on. You want to have payment terms in your scope of work. You want mobilization costs up front, 10% due in mobilization in your scope of work. That way, because you have to get your people to the job. You need to get the supplies to the job. So if you're not given any compensation up front, you're losing that money. That money's coming out of your pocket. Your scope of work can be drafted in a way to avoid that issue because the owner is then on the hook to pay you a mobilization fee, which covers that. So you're protecting yourself from any kind of cash flow issues. The next topic we're going to talk about is force majeure. I'm sure everyone's heard about that. It changes every year. So the purpose of this presentation is to explain how contracts are living, breathing creatures. I mean, every time I talk to a client, they're saying, I don't need to change my contract. I use my contract for 15 years and nothing's ever happened, which is great. And we love to hear that, but nothing ever happens until it happens. And then you're stuck with a 15-year-old contract, which has bad language in it, doesn't account for what's going on today, and then they're in a lot of trouble. They get screwed by it. So you want to be always abreast of what's going on in the world to be able to modify your force majeure language. So courts interpret force majeure provisions very narrowly. So you want to make sure that you list out exactly what you want to be force majeure. So you want to include things like pandemics. You want to include things like labor shortages. You want to include things like supply chain disruptions, tariffs. All this will protect you if something happens that causes a delay or an issue to your work. So we have tariffs are the big hot issue today. There's tariffs being threatened once a week on a different country. And that's important to know for people in the construction industry because we get materials from all over the world. We're getting lumber and steel from Canada. We're getting lumber and steel from Mexico. We get a lot of the semiconductors and different types of wires from Europe for data centers. You need to know if your materials are going to be impacted by tariffs. That's not only going to affect the cost, that's going to affect the time it takes to get to your project because it has to go through customs. The new custom requirements for tariffs are onerous and it takes time. So to mitigate these delays, you want to just source your materials from local suppliers and to people local mom and pop stores that have warehouses, but have people that you can get the materials for when you need them. Don't be fully reliant on international materials because you never know when the price changes. You're going to have to eat that cost. That again talks to your bottom line, and it's going to be delayed. So we also have worker shortage, which is definitely coming into the news more now with immigration crackdowns. These are maybe a little bit older stats, but all the major industries are predicting that construction labor forces need to grow by 50,000 people, 6,000 people per month. And everyone's fighting for these skilled laborers. So if everyone's fighting for the same labor pool, it's going to run out. So I like to advise my clients to increase the broader populations of who you're going to work with. Women, veteran programs. There are a lot of veteran programs that provide veterans who are looking for work in the construction industry. You also want to begin setting up kind of like a framework with trade schools so you get their qualified employees that come and start working with you. Now the last topic we're going to talk about is prompt payment liens, and mechanics liens. This is something that we cover here at Anders & Kill a lot. When you are a contractor and you have an agreement with an owner, if you're getting partial payments, the owner is going to require a partial lien waiver for the amount of money you've been paid. So a mechanics lien is a legal tool that ties a security interest to real property. This is the contractor and supplier and subcontractor's best friend because it hinders the owner from being able to sell the property. It clouds title, and they're going to want to remove the cloud on title quickly. So they're going to be more willing to come talk to you and have a conversation to try and resolve the issue and make payment. So again, who can file mechanics lien? Contractors, subcontractors, labormen, material men. And it's weird because New York courts have expanded the list to include other people, including architects, engineers, and surveyors. This is important because the lien law itself does not include architect, engineers, or surveyors. So the courts have been expanding the scope of who can file mechanics liens. Now, mechanics liens require very, very strict deadlines. It's one, if you miss it, and that's it. So if you're doing work on a private project, it's 8 months after your work is completed. The last day you perform work. If you're working on a single family home, it's 4 months. For a public project, mechanics lien deadline does not begin to run until 30 days after the work is completed and accepted by the owner. Now, filing the mechanic lien is step one. You then have to foreclose on your mechanic's lien within 365 days of filing the mechanic's lien by starting a lawsuit to force a sale of a property. This is something that owners want to avoid at all costs. And what I found in my practice is that filing this mechanics lien gets them to the table, gets them to begin negotiating, and then you can get payment for your client who has been dependent on this money that's being withheld for them for really no legitimate reason. One of the pitfalls with mechanics liens is willful exaggeration. Section 39A of the lien law lays out what willful exaggeration is. It requires intent. Merely miscalculating the amount of money you're owed is not going to be willful exaggeration. But if they can prove that you are intentionally inflating what you're owed in a mechanics lien, they can strike your lien and make you pay the attorney's fees of the owner. So intent must be proven. That's the key on willful exaggeration. But if they can prove intent, your client is now paying legal fees, and they're not going to be able to have a mechanics lien for the money they're owed. So they lose their mechanics lien, and now they're paying $50,000 to some other law firm that made a sort of filed a petition to define your lien as willfully exaggerated. Another issue with mechanics liens is slander of title. So slander of title, you need to prove that they filed the false lien with malice, what you knew was false, actual financial damages, not speculative. Not that I could have sold my building, but I couldn't, so I lost that money. But an actual sale that was going to go through that didn't go through because of their lien, and direct causation between the lien and the loss. Now, good faith disputes about what money's owed is not going to be slander of title. Bottom line here is an honest dispute does not equal slander of title. All right, so now I'm going to pass it over to my colleague Josh, who's going to present on risk transfer and indemnification. Here you go, bud.
Thanks, Chase. All right, my portion of the presentation is going to cover some considerations that companies should contemplate when drafting and negotiating risk transfer provisions in their contracts. I'm going to be focusing specifically on the indemnity provision. So the two most common and some might say most important provisions for risk transfer are the indemnification provision and the insurance requirements provision. You might be asking yourself, well, why do we need both? Shouldn't insurance cover everything? Well, the answer to that is in theory, yes, insurance should cover everything, but in reality, insurance companies deny coverage all the time. In my experience and in my practice, as a few of the Anderson Kill attorneys in here can attest to, insurance companies will manufacture a host of reasons for why they're going to be denying coverage. Sometimes as an additional insured, you may not have the opportunity to inspect a policy, and you likely only receive a certificate of insurance from a broker. There's situations where the policy might exhaust itself because there's other claims. And being able to go back to the other party and say, you have to indemnify us is very valuable. So there's a few things to consider when first navigating contractual risk transfer. What are your goals walking into the negotiation? What kind of risk is your company exposed to? And is it coming from external or internal sources? What liabilities is your company exposed to at job sites? It's important to know that there are limitations on how broad indemnification provisions can be because there's anti-indemnification statutes that certain states have adopted. Every jurisdiction is different, so you're going to want to look at each state's anti-indemnification statutes. Hello, Alan. It's coming in hot with some fresh waters. Yeah, thank you very much. So you're going to want to look at every state's anti-indemnification statute and understand what you're permitted to be indemnified for. Most states are going to be different, but the prominent view is that you cannot be indemnified for your own negligence, and that's the law that New York follows. So as a practice point for the attorneys in the room, when you're on trial in an underlying case, when you submit questions to the jury and a verdict sheet, you want to make sure to ask the jury to apportion liability based on Labor Law 200, which is a codification of general negligence. Labor Law 240, which is a statutory violation that requires no negligence. And Labor Law 241, subsection 6, which is statutory violations or violation of the industrial code, which does not automatically render a party negligent.
So I want to tell a story, I guess a tale from the trenches. I have a case now where in an underlying trial that ended years ago, the trial strategy was to group the owner and GC together. The court found that was their strategy. They were stuck with that. And then the court wouldn't let them apportion liability, and they attributed the liability to the owner and GC together. After that trial happened, they then sued my client for indemnification. So now we're having this argument where it's, are they stopped from now trying to apportion the loss between the owner and the GC, because the owner in all these cases has less negligent, are they're going to be found to be less negligent. Most of the time, courts apportion 1 to 2% to the owner, and the thrust of it will be on the GC. So we argue that they made a strategy that they're grouped together for negligence purposes. Even if the court would find the owner not negligent, they're stuck with their prior decisions. And this, I think Josh will talk more about how to avoid that issue going forward, but just something to keep in your mind.
Thanks, Jason. Moving on to some other related provisions that relate to risk transfer outside of the indemnity provision. You also have limitation of liability, and that's a contractual clause that restricts or excludes the amount and types of damages that one party may recover from another party. There's also waivers of subrogation, and that's a clause where one party agrees to give up their insurer's right to seek reimbursement from another party for damages paid out in a claim, preventing costly lawsuits between related entities. The insurance requirement clause allocates risk by mandating that contractors and subcontractors maintain specific coverage, including naming certain parties as additional insureds. And there's requirements to provide proof of insurance before starting work. All right, so now moving on to the main topic here, which is indemnity agreements. What does it do? It shifts costs and defense obligations to pay to the indemnitor, so the party indemnifying. We have some sample language up on the screen here where a service provider shall defend, indemnify, hold harmless the client from and against, and all claims, demands, suits, judgments, losses, liabilities, damages, costs, or expenses of any nature whatsoever. And I want to emphasize caused by, solely by. Now, caused by language establishes that the indemnifying party must compensate the indemnity for losses that have a direct causal relationship to the specified conduct, breach, or circumstances. It could be any of those. This is typically interpreted as requiring proximate causation and not just but-for causation, which requires a direct link between the indemnitor's acts or omissions and the resulting loss. In other words, something more than a mere association or coincidental timing. So this language is very narrow. It requires a proven causal link. Caused by demands that you prove, it demands that you prove causation, and that the specified act or omission actually produced the harm. By comparison, some provisions may include an arising out of language, which means any connection, however tenuous, if loss has any relationship to permits, indemnity is triggered. Some provisions may include language referring to causation by multiple parties. If other factors also cause loss, caused by language may allow apportionment arguments. All right. So with respect to indemnity agreements, there are three major considerations during the negotiating and drafting phase to be aware of. The first is whether the indemnity provision can be enforced. And as I mentioned earlier, there's anti-indemnity statutes and certain laws that jurisdictions that you need to be aware of because they do vary. And then there's three types of indemnity forms that can impact whether or not an indemnity agreement can be enforceable in these jurisdictions. I'll mention them briefly for now, but expand on them in a bit. But there's the broad form indemnity form, there's intermediate form indemnity, and there's also limited form. And to maximize enforceability, it's important to comply with the state's anti-indemnification statute or other relevant law, and then ensure that no one is being indemnified for their own negligence, and consider what state is chosen for the choice of law provision in your contract, because that'll determine which state's anti-indemnification statute is going to be applied.
Really quickly, if the owner hands you a contract to review, it's going to include a broad form clause. So again, know who you're working with, and if you're the one preparing, you have a tighter control of what kind of language you're going to use. With the owners hand you a document to mark up, make sure you really spend a lot of time reviewing the indemnification provision because they're going to try and get you on the hook for everyone's negligence on the project except their own. And you want to make sure that you're aware of that. You take that into account and you try and negotiate.
All right. So, yeah, as I just mentioned, perhaps the biggest considerations when drafting indemnity provisions is the scope of the provision and the choice of law provision governing the entire agreement. So the scope of the indemnity provision and the way it's drafted go hand in hand with the choice of law provision, because those states' laws will end up determining whether that indemnity provision is going to be enforceable. So moving on to just to take a look at New York law. And as you can see, this was the general rule that I stated earlier. Under New York law, a party seeking contractual indemnification must prove itself free from negligence. To the extent its negligence is contributed to an accident, it cannot obtain indemnification under such agreements. Now, with respect to partial indemnification, the New York Court of Appeals has held that the addition of language such as to the fullest extent permitted by law limits rather than expands the promisor's indemnification obligations. So the to the fullest extent permitted by law language, that'll actually permit a general contractor, even one that's partially negligent, to pursue contractual indemnification and recover for damages caused by a subcontractor's negligence. That didn't change. That's good. All right. So now I had mentioned earlier that there's three different types of indemnity forms that are important to consider when you're drafting your indemnity agreement. The first one that I'll discuss is the broad form. As you can see up on the screen, a broad form it indemnifies an indemnity for an indemnitor's sole negligence, an indemnity's sole negligence, and the joint negligence of the indemnitor and indemnity. Sorry, twisting words here. And so it's irrelevant which party is actually at fault. The goal of these types of provisions are just a wholesale transfer of risk to the indemnitor. And in reality, enforcing these types of provisions is very difficult, especially in the state of New York. And so just to give a little practice point for contractors, these types of indemnity forms, the broad form specifically, is very bad for contractors. It's going to force them to cover losses for any cause, including negligence of others or the project owner, creating a massive financial risk beyond your control, potentially exceeding insurance, triggering defense costs before fault is even proven, and leading to unfair burdens. This overextends you as a contractor's liability. It shifts risk unfairly, and it can be financially devastating as they become responsible for others' mistakes. Now, shifting gears to the intermediate form. An intermediate indemnity form means that the contractor agrees to cover losses caused by both the contractor, and thank you for switching that. Means the contractor agrees to cover losses caused by both the contractor and the owner together, but not losses covered solely by the owner's own negligence. Intermediate indemnification is generally not ideal for contractors. It's a compromise where they cover losses for their partial fault and often even the owner's minimal fault. So owners will prefer broader forms to shield themselves. So contractors should attempt to negotiate for limited indemnity, which I'll explain next, to avoid significant financial exposure. And so, yeah, so you'll see on the screen, there's a simplified version of this type of language that you'll see in these intermediate form indemnity agreements. So now shifting gears to the limited form. Limited form indemnification is great for contractors. It caps the financial exposure to losses directly caused by their own negligence, preventing them from being liable for the owner's fault or uncontrollable site issues. It promotes fair risk sharing and aligns with typical insurance coverage, which makes it very enforceable and predictable. These types of forms protect the contract from bearing the full burden of the project's entire risk, and it ensures that only what It only covers what they truly caused. Did you want to say something?
Go.
You looked like you wanted to say something.
You gave that.
Fair enough. All right. So some thoughts to consider when determining whether the indemnity agreement is actually enforceable. So does the choice of law provision choose a state's laws that will allow the indemnity agreement as drafted to be enforced? For example, if the choice of law provision states that New York law governs, then an indemnification clause that does not include the language to the fullest extent permitted by law or tries to provide the indemnification for their own negligence, that's something to look out for because it may not be permitted. Intentional acts are generally not covered by indemnity agreements, and courts often find that indemnifying a party for their intentional wrongdoing violates public policy. So New York courts have long held that you cannot be indemnified for intentional acts. Carefully drafting the indemnity provision is key, and recent case law has bared this out. For example, in a case decided this year, DeBrino v. Rockefeller Center North, an owner sought to enforce a typical indemnity provision against one of its subcontractors after a laborer was hurt using the subcontractor's ladder, but the laborer did not work for the subcontractor, was not forced to use the subcontractor's ladder, and the subcontractor was not aware that the laborer was using their ladder. As a result, the Court of Appeals ruled that the subcontractor owed no indemnity to the owner. The laborer's unauthorized use of the subcontractor's ladder did not arise out of or result from the performance of the subcontractor's work. So notably, the contract also did not include a broader indemnification clause, but the court refused to apply it because doing so would render a more restrictive indemnification provision meaningless, which is a violation of the basic rules of contract interpretation. So moving on to the next. And I just want to highlight some major issues and sort of a takeaway when considering, drafting and negotiating indemnification provisions as well. So indemnity clauses are highly dependent on the financial condition of the party that is agreeing to provide indemnity. And this is something to be aware of because if you can't go back to them and actually recover, it's going to be a problem. If the indemnitor is in poor financial condition, there's a chance that recovery is going to be extremely limited and render the provision essentially useless. Indemnity agreements also do not provide direct rights under an insurance policy. It's definitely something to be aware of. Those rights are going to be established by other provisions in the contract which govern insurance requirements. We have some great presentations later in the day today that will be going over some more of those insurance requirements to be aware of. And finally, an available insurance clause in an indemnification agreement links the indemnitor's liability to insurance coverage. It often caps or limits and prioritizes the use of insurance proceeds to cover damages. And that's something to be aware of to have in your provision as well.
I just want to add a point to that. Was an excellent point by Josh, is that, you have to know the financial condition of your subcontractors or the subcontractors. A lot of times these are really small companies, and you'll notice if you're in the business for long enough, you'll see Jason Kozak Construction, and then 2 years later it's Jason Kozak Construction 1. 2 years later it's Jason Kozak Construction 2. That's because these small companies are not able to afford the indemnification obligation, and they close down. So the additional insured piece that Josh brushed on is very important to ensure that your risk is actually going to be transferred. You cannot only rely on contractual risk transfer, because unless you're dealing with a major company like a Turner that has the money that can pay for the contractual indemnification, it's useless. And you need to also make sure that your client's an additional insured under the policy, which I'm sure this is another general practice point for drafting contracts. When you're drafting your insurance provisions, require a full copy of the policy. A lot of times I see contracts that just say, give me a certificate of insurance, and that's good. Certificate of insurance means nothing. They can be fake, they can be changed, they can not be enforceable. You want to have a full copy of the policy. See that you're named, either directly on the policy, or it says all parties agree to via insured contract, and then go back to your contract and make sure that you're going to be named as an additional insured under that policy. Because if there's a loss, you don't want to get stuck paying all that money, and in the back of your head, you're like, don't worry, I got contractual indemnification. And then you go and file the lawsuit, and the mom and pop construction company you use closed, and they now open up another entity somewhere else. So it's important to know, who you're dealing with. And that's kind of what he just hit on. That's really important to impress on everyone here, that the tips we give you are just a starting point in drafting and amending your contracts. You need to think through who you're dealing with, because every situation is going to call for a different outcome and different negotiation. And if you have fears about who you're doing work with, whether they're financially stable to recover for a loss, then you need to really harp on other ways to shift your risk, which other people here will talk about additional insured coverage to make sure you're covered. So I assume, to no surprise to anyone, I spoke a lot faster than I was supposed to. So I will kind of go over some of the key tips and pointers that I and Josh want everyone here to leave with. So first, we talked about the Avoid Act. That's this new law that's going to go into effect in April of this year. The Avoid Act is going to speed up litigation, and you're going to have to bring parties in directly. When you're drafting contracts, require directories, require updates, require copies of all contracts and subcontracts to be provided within 2 to 5 days of execution. Keep them in your file and be aware of who is who on your project site, because you never want to be stuck on the 29th, the 50th day after you filed your answer, and you have no idea who the electrician was. And you're still trying to find out, time's passing. And then on the 61st day, you finally out, you file your lawsuit, and then the court kicks it out. And then guess what? You're the first person who got their case kicked out by the Avoid Act. So going forward, everyone's going to cite your company's name when they say late filing is insufficient to, it requires dismissal under the Avoid Act. No one wants to be that footnote. No one wants to be the lawyer involved in that footnote. No one wants to be the construction company that is involved in that case. If I had Jason Kozak Construction, I wouldn't want people to cite the Jason Kozak Construction rule that if you're too slow, you blow. So that's how you go with the Avoid Act. That's part one. Then we talked about scope of work, and both Josh and I talked about arising out of language. Avoid arising out of language as often as you can, because you want to narrow everything to what you're agreeing to provide. So in your scope of work, arising out of the plans and specs, as we discussed, really opens you up to a lot of potential issues that people can come and require you to do without payment. The same thing happens with indemnification. Arising out of your work could mean a subcontractor performing work that you subcontracted out. And I think later today, we'll have a much more thorough description of your work, and it's going to be a great session. Next, we talked about force majeure provisions. Look, I mean, every month something new is happening, and I think to myself, I got to make sure the contracts that I'm drafting includes this, because you don't want to miss out on it. So how many people tried during COVID-19 to pigeonhole pandemics into force majeure provisions, and because force majeure provisions are narrowly interpreted, everyone lost. You have to live and learn by your mistakes. So you can't just treat your contracts as a holy grail. It's a living document. You need to revisit it at least once a year and look at what's going on in the world and look at what you can change to protect yourself, whether it's adding pandemics, adding labor shortages, adding tariffs, adding supply chain disruptions. There's constantly wars going on, wars being started, and that's disrupting shipping lanes. Who knows what's going to happen with the Panama Canal in 2 months? You want to be ready to have disruptions to your supply chain included in your contract, because that will protect you at the end of the day. And the whole point of drafting a great contract is protecting yourself. You're never going to be scot-free, but there's always going to be avoidable mistakes that a properly drafted contract you can avoid. So the key to drafting a great contract, as Josh and I have just discussed, is avoiding the avoidable mistakes. So these are things that aren't going to change. They're just going to evolve as we continue practicing. So always go over your scope of work provisions. Make sure everything is tied to a specific plan, specific specification. That way you have very strong claims for change order work, and every contractor in this room knows how onerous getting paid for a change order is. And that's really the thrust of every litigation that I'm seeing recently are change order disputes and payment disputes arising out of change orders. So if you have a great document, great document scope of work tied to specific drawings and specific specifications, you may not have to worry about that. You go to court and you say, we're here to interpret the contract as drafted, as intended. And as you can see, our scope of work was only drafted and intended to cover the work pursuant to these documents. And to the extent they seek to rely on revised or updated plans or revised or updated specs, that's not in our scope of work. And guess what? The court's going to say, my hope is the court's going to say, this is not ambiguous and this is a scope, this is a change order work. I guess the last thing we can talk about is mechanics liens again, really quickly. Mechanics liens should be your contractor, your material supplier's best friend. Mechanics liens are even more effective on projects that are bonded. If you know your project has a surety bond, if you can get a mechanics lien placed, the surety bond will often step up to the plate, make a payment to you. That way it clears the property of any kind of cloud on title, and then they'll fight it out with the contractors on their own dime. So you can walk away with your payment and you're getting paid by the surety bond, which you really don't care about. You're getting the money into your pocket and you can now move and go on to the next project. But then the surety bond has to fight that fight with either the guarantors, the people on the project. So it shifts the burden from the contractor supplier to establish they're entitled to payment, and it shifts it on to the surety bond. That's a practice tip that I've learned and have been utilizing recently, and it's been very effective to get my clients paid. The first question I ask when someone comes to me with a payment dispute, I said, hey, is there a bond? I don't know. Let me find out. And if the answer is yes, I'm immediately ecstatic. I say, find out who it is. And I send a nasty email that says, you owe us all this money. All this money is a failure to pay in full will result in a mechanics lien filed by January 29, 2026. Failure to pay in full will cloud the title, and you'll have to deal with that going forward. My authority to negotiate with you also expires on January 29th, and they're going to step up to avoid the slander, avoid the cloud on title, and they'll make the payments to you. Josh, any last words?
No, I think you said enough for the both of us. Are there any questions that we could, answer in this form at least? And if not, we do have one.
What's the comparison between the entire controversy doctrine in New Jersey and the Avoid Act in New York?
So I do not know enough about the entire controversy doctrine to answer you right now, but I think that that allows you to bring people in as you discover their liability.
It requires you to bring them in the litigation, in the instant litigation. You can't litigate with one, then litigate with another.
But you can bring them in later in the dispute. And so instead of, you can't start a new dispute against them, you can bring them into your action. So there's no, again, this can be verified by after, but to my knowledge, that only requires you to either amend your complaint and bring them into your initial action. But the Avoid Act is going to require you to name everyone within 60 days. And it's going to cause a logjam in the courts. And everyone here who gets frustrated with how long litigation takes, it's going to get much worse. And that just not good. But that's it for us.